And welcome everybody to the webinar Winning Fights for Aboriginal Rights, Title and Power in Canada, Key Legal and Campaign Developments. This webinar is brought to you by the Indigenous Resources Network, which is a project of the Indigenous Environmental Network, or IEN, and the Business Ethics Network, or BEN, and BEN is a project of forest ethics. And we have great speakers today. I'm going to let you take a look at them while I read their bios, quick bios. And speakers, can you all nod if you can hear me okay? You can all hear me okay? Okay, great. Okay. And we have just a picture up of Jess because she's having some internet connectivity issues. So no webcam today for her, but we wanted to let you see her a little bit in the beginning here. Again, welcome everybody. Jess Housty is a councillor of the Heiltsuk Nation, one of the First Nations challenging Enbridge's northern Gateway project and campaigning to enforce a ban on trophy hunting. With her Heiltsuk friends and family on the central coast of BC, Jess is a young First Nations leader who's had a view on Canada's national interest through the business end of the proposed Northern Gateway pipeline. And we welcome Jess. I'm going to do quick bios on everybody, and then we'll go ahead and do a little bit of housekeeping, and then we'll start. Gregory J. McDade is Councillor to the Saik'uz First Nation and the Stellat'en First Nation. He's a managing partner at Ratcliff and Company and a lawyer in the Saik'uz and Stellat'en First Nation and versus Rio Tinto Alcan case, which just had a very big win announced last week. So very timely on this webinar, very exciting. He supervises major First Nations litigation. A large part of his practice is negotiation of impact benefit agreements and Aboriginal consultation and accommodation litigation in respect of major resource projects in BC, the North, and Ontario. Welcome, Greg. Our next speaker is Jane Nelson, General Counsellor to the Tsilhqot'in National Government and Associate Counsel, Woodward and Company, LLP lawyer in the Tsilhqot'in Nation versus British Columbia case. Jay is committed to assisting First Nations in achieving recognition of their Aboriginal rights through education and awareness, consultation and accommodation, negotiated settlements, and, where necessary, litigation. And we also have Chief Roger William of the Tsilhqot'in, Vice Chair of the Tsilhqot'in National Government, and plaintiff in the Tsilhqot'in Nation versus British Columbia case. And back in April 18th of 1990, the Nimaya trapline action was brought by plaintiff Chief Roger William in his capacity as Tsilhqot'in Chief on behalf of all Tsilhqot'in and all Tsilhqot'in people in the Supreme Court of BC versus Her Majesty in the Queen and Right of the Province of British Columbia, the Regional Manor of the Cariboo Forest Region, and the Attorney General of Canada. This was part of a decades-long legal and campaign battle, which resulted in the huge victory at the Supreme Court of Canada last year. I want to say welcome again to all of our speakers, and just a little bit of housekeeping for everybody. This is being recorded for posted and sharing, and we will get you the link once we have it up. And with that, I'm going to go to our first speaker, who is Jane Nelson, and I'm going to actually close down the webcams for the other speakers to help us keep our connectivity. And we will have Jay, and then Chief Roger, and then Greg, and then Jess. All right, bear with me for a moment while I close the other webcams. All right. And Jay, I have a few pictures from the Supreme Court case and that map we talked about, and a couple of other photos to scroll through. Let me just let you take a look at those really quickly, and I'll just try to move around to the right spot as you speak.
Sure, thanks, Dan. Those look great.
Okay.
So should I just get started then?
Yes, yes, please.
Excellent. Okay, thank you, and good morning, everybody. I think my job is to kick things off by talking about some of the precedents that were set by the Supreme Court of Canada decision. You're seeing some of the pictures. In the Tsilhqot'in Nation case in June of 2014. And I'm going to try and get to maybe 5 main precedents that the case sets, in my view. I think I have about 8 or 10 minutes, so I'm going to rattle through them fairly quickly and hopefully get to all of them and let the other panelists have a go. So right into it, precedent number 1 set by the case is that Aboriginal title is a real thing. It exists on the ground as a real legal interest, and it's not some abstract legal theory that's in the law books and argued by lawyers, but it's actually on the ground. It can be proven and it can be enforced. And that might sound pretty basic and obvious now on this side of the case, and it's easy to forget that it was a real question before the Supreme Court of Canada decision in this case, whether the courts would actually recognize Aboriginal title as a real thing on the ground. You might know that the Supreme Court of Canada's history with this question goes back to the Calder decision regarding the Nisga'a title claim in the 1970s. And that case was essentially a tie game with the judges splitting on the question of whether title still exists today or whether it had been extinguished in British Columbia, at least by colonial legislation, or enactments. So there was really no clarity coming out of that case about or confirmation that title exists. The next big case, of course, was the Delgamuukw case of the Gitxsan and Wet'suwet'en people, and that was a huge victory. The Supreme Court of Canada decided once and for all Aboriginal title is not extinguished in British Columbia. It still exists. It can still be proven. But in that case, the court found reasons not to actually declare Aboriginal title on the ground for the Gitxsan and Wet'suwet'en. They sent it back to a new trial for reasons we won't get into. But in that case and in subsequent cases, while affirming that it exists in legal theory, the Supreme Court of Canada and other courts have stopped short of actually declaring it on the ground. So by the time we got to the Supreme Court of Canada, being 40 years since Calder, 18 years after Delgamuukw, and title was still not recognized to a single square inch in Canada on the ground outside of Indian Act reserves. So there was a real growing serious concern among First Nations that Aboriginal title was becoming something of an illusion that the courts talked about and held out, but that the courts would never actually recognize it on the ground and give it real life. And in part, I think, because of the practical implications, what that would mean, and some fears in the courts and government around what is the fallout from recognizing title. And I think the government's maybe banked on that a bit, that when push came to shove, the courts wouldn't take that final step. But when push came to shove, the Supreme Court of Canada, as you know, did recognize Aboriginal title for the first time on the ground. And so we know now that it does exist. The courts will recognize it, declare it on the right facts, and they'll enforce it. And so it is now a force that has to be reckoned with, a legal reality that has to be reckoned with. Not only in BC, especially in BC, where we have less treaty issues than most of the rest of the country, but in other places in Canada as well, Aboriginal title is a live issue. So that's precedent number 1. Precedent number 2 is that Aboriginal title is territorial. It's big. So after Delgamuukw, when the Crown's arguments failed and it was clear that title still exists in BC, the next backup argument from the Crown was, okay, if it does exist, it's so small that it's practically meaningless. And the BC Court of Appeal in the Tsilhqot'in case, they bought into that argument, and they agreed and said Aboriginal title as a matter of law, no matter what the reality was on the ground or how the Aboriginal group used the land, as a matter of law, Aboriginal title can only be proven or established to very precise small spots. So the examples they gave is if you used a particular salt lick frequently to hunt animals, moose, then you might have Aboriginal title to that particular salt lick, but not to the hunting ground. That's too much. Similarly, they said if you stood on a particular rock to gaff salmon, you might have Aboriginal title to a rock, but not to that broader fishing area. I think maybe they would go so far as to recognize title to a village site that was occupied maybe year-round, And that's the extent, that's as far as title would ever go in the eyes of the BC Court of Appeal. And so that was a huge issue going to the Supreme Court of Canada, dealing with what was called a postage stamp theory of Aboriginal title, for obvious reasons. And fortunately, the Supreme Court of Canada, they rejected that postage stamp site-specific approach to title once and for all, and confirmed that Aboriginal title is territorial. It's not limited to those little spots. So it's not just village sites, but it extends to all of the regularly used hunting and trapping gathering areas that a First Nation used at the time of sovereignty and exclusively controlled. And we refer to it, it's not a legal term, but we've been referring to it colloquially as the breadbasket lands, those lands the nation, pursuant to their way of life, used regularly, season after season, year after year, hunting, trapping, fishing, gathering, all of those activities that sustained the community and the culture and the economy. And so I think, Anne, if you could pull up that map through your webinar magic, I'm not quite sure how that works. There you go, great, thank you. You'll see that that's the claim areas in light green, and the Supreme Court of Canada confirmed Aboriginal title to that dark green swath you see to the center and then running up the river to the north. So that's a pretty substantial area of land. It's not a postage stamp. It's about 1,800 square kilometers of land. So Aboriginal title is real, it exists, and it's big. It covers a lot, potentially a lot of area. So that's precedent 2. Precedent number 3, moving along. The reason that's important is because Aboriginal title is ownership and governance of the land. So up until Aboriginal title is recognized, the courts have been mainly dealing with Aboriginal rights to hunt and to fish, to trap, those types of things, which are important, and they protect traditional activities, but so far they haven't conveyed an ownership right to the land or a right to manage and govern those lands. And that's where Aboriginal title really goes beyond that, and it's a collective form of ownership of the land and the resources, and it's the right to control how those lands and resources are used. The First Nation has that power, the right to proactively manage the lands, and the right to the full economic benefit of that land. So they're no longer, those are not Crown lands, and they never were. Those are Aboriginal title lands owned by the nation. So it's a very powerful and important right. Precedent number 4, moving along, Aboriginal title should be a real concern even before it's proven, and that's important. And I think it's fair to say the province has never reckoned with Aboriginal title on the scale that's been affirmed by the Supreme Court of Canada. It's really, the province of BC, other provinces across Canada really thought and struggled against Aboriginal title on the basis that it's these postage stamps, and all of our legislation, all of our policies, everything is based on that view, and that's been blown up now. We know that's wrong, and we have to deal with title on this large scale. And I think it's also fair to say that every First Nation has Aboriginal title lands if they haven't entered treaty or some other type of agreement, and potentially even then. And those lands in most cases are going to be extensive. They're, I think it's safe to say most First Nations had hunting and trapping grounds they regularly used, gathering areas that they controlled, and those would be title lands. So the reality is that British Columbia, other parts of Canada, are blanketed in Aboriginal title lands. Now, are those lands, title lands, proven and established in court? No, they're not yet. But I think we all know about the costs and delay and the burden it puts on a First Nation to prove Aboriginal title conclusively in a court. But it should still be a real concern for government and industry, and the Supreme Court of Canada made that clear, because it said even before you've done what the Tsilhqot'in have done and go through court and get the declaration of title, even before it's been proved in court, a strong claim to Aboriginal title really ramps up the Crown's duty to consult and accommodate the First Nations. So right away, First Nations entitled to a lot more say in what happens on those lands if there's a strong evidentiary claim to title. And in some cases where the impacts are going to be extreme, where there's a strong claim, it may even require the full consent of a nation before lands can be developed, even before proof. The court also said where the claim is particularly strong, that appropriate care has to be taken to preserve the interest pending a resolution by the court. So again, another halt on use of that land over the objections of the First Nation. I think the really critical piece that the court said is that if the Crown approves development approves some development before Aboriginal title is established, but then Aboriginal title is later proven in court by that nation, the Crown has to go back and revisit that decision. And if it's offside, if it's unjustified, it has to cancel that project. So that creates a lot of uncertainty if you don't deal with Aboriginal title right up front. And I think that's why we're seeing now some new Aboriginal title claims being brought that directly target particular projects that are opposed by a First Nation. So I'm thinking of the Lax Kw'alaam's Aboriginal title claim that's been brought to Lilu Island in opposition to the Pacific Northwest LNG terminal. And the Kamloops Indian Band and Tsilhqot'in have brought an Aboriginal title claim that's targeted at the Ajax mine in that area. So you can see the power that this gives even before Aboriginal title is claimed. And I think I'm probably going a bit long on my time here, so I'll just very quickly say the fifth precedent is the practical importance of consent of the nation now. And the Supreme Court of Canada said, you know, the fastest way, surest way to cut through all of this uncertainty is for government and proponents to get consent from the First Nation right from the start. It might not be a legal requirement in all cases, but if you want to deal with the uncertainty of unproven title, go out, get consent, and that's the best way to move forward. And I think that really shifts the discourse from consultation over to consent of the nation. And maybe I will leave it there, and I look forward to the presentations from the other presenters. Thank you, Anne.
Thank you, Jay, very much. All right, I'm going to close Jay's webcam for now and see if I can bring up Chief Roger. Sending that webcam invite. We'll see if it works. There we go. Very good. Very good.
Hello?
Hi, Chief Roger. Can you hear me?
Yes, I can hear you.
Okay, wonderful. We can hear and see you. And I'm just going to show you some of the slides that I thought would be good to show, and I can kind of move around during your presentation and show these. But I'll just let you take a look. That's the map that that Jay was using, and some pictures from the courthouse. And I think the foreground in this picture is in the traditional lands area, and then this is just some of the headlines after the case was won, and seeing other First Nations plan for using the precedent. So just those are some of the slides, and I'll move around as you speak.
All right. So I guess you know, my role in this webinar is to talk about what we did and, you know, give some advice. We did a lot of research. We've learned from many First Nations across this country, on First Nations, woodworking company, Rosenberg, Tsilhqot'in National Government, my elders in Honey. I'll just go back to 1862. At Tsilhqot'in word we say a skydam. A skydam is a Tsilhqot'in person at 1862 who had language, culture, honor, respect, laws, and when this person took you into their home, it was, you were well looked after. It was just like your home. So since then, there's been changes. 1862, Tsilhqot'in War is a big part of our history, and that's something that all our children learn. And moving forward to the smallpox, from the smallpox on the residential school, reservations, and then for Tsilhqot'in, you know, starting starting our declaration of August 23, 1989, our first woman chief, Annie C. William, was on council when we declared our caretaker area inside the Tsilhqot'in, in short saying nothing's going to happen without our involvement. So this is coming from our elders, from our people. And from there, filing a 1990 trapline case to Supreme Court of BC, and then a roadblock in 1992 on May 7th for 2 months. And out of that came what is also known as the Brittany Triangle, Brittany Lake Forest Management Plan, which is between the Tsilhqot'in Lake, 80-kilometer long, the Tsilhqot'in Lake, 60-kilometer long. The two rivers meet, creating the Tsilhqot'in River. We call that whole area Tsilhqot'in in our language. And between 93 to 97, we had a management plan, forestry management plan, a strategic operating plan. And this involved our elders, our youth, our people, and many meetings involving with the government. At the end of the day, and you know, the frustrations from both sides, our people turned the plan down. Too much timber happening at once, and so the government, the Ministry of Forest, was going to go ahead with the Brittany Lake Forest Management Plan in 1998, whether we liked it or not. So there was a roadblock again in 97. They were going to put a road into the northern tip of our trapline, and an agreement to do a further study, which never happened in the end. But we filed a title case in 98, and in 2002 to 2005 was the trial. The support of the Tsilhqot'in Nation and the Union of BC Indian Chiefs, the 70 First Nations, the BC Summit, together as a whole, you know, we learn from the history, our First Nations people and the government of this country and the process. So doing research and moving forward was very important. Elders and leaders from all of our Tsilhqot'in communities testified, and we had expert witnesses. Decision came down, and we all know the decision in 2007 in November. Then we appealed. We did try in 2008 to negotiate with BC and Canada, which Canada chose not to be involved but chaired the process. No agreement, so we appealed again to Supreme Court of BC in 2010, decision coming down in 2012. In terms of the rights to hunt, to trap, to trade, and also to catch and use wild horses to 100% of the area, that decision from the three judges in Supreme Court of BC remained. So that was the victory, that was a celebration. But in terms of title, they wanted us to go back and go more postage stampage style, where maybe we might have title where we stood on a rock to fish or behind a rock blind to hunt. You know, exclusive use, and we didn't agree with that. So we moved forward with an appeal to the Supreme Court of Canada. First Nations across this country intervened in our area since the roadblock in 92. Before, there's a lot of history with the local operators. Some of these local operators are at least 4, 5 generations, and some of them come and go. But they, along with the Council of Canadians, intervened in the 2013 appeal to Supreme Court of Canada, and they intervened, and the support what we put forward was you know, we were really happy with, and everything came together. So we were pretty optimistic of the outcome, because we've seen both BC and Canada fall apart in Supreme Court of Canada. In Ottawa, we had a Title Express drive with our elders and leaders going across Canada, stopping in each country. So what's really important is, you know, doing our homework as a nation. Tsilhqot'in is one of 6 Tsilhqot'in communities. With all the other 5 communities supporting us, we were able to move forward. When the decision came down last year on June 26th, it was huge, 8-0. The 8 judges, and it's a Tsilhqot'in Aboriginal rights. It's a Tsilhqot'in title. Tsilhqot'in is one of 6. So in the title land, we have, you know, what we call islands, and these islands are local operators who have they're doing tourism or ranching. They have the residents, and they've been getting their permits and license from the Crown government. Now, with the decision on title land, they need to get their permits and license from the Tsilhqot'in Nation. So right now, as of last year, we're in transition. We signed an MOU in September 2014. We're close to an agreement on a 5-year negotiations process, which will be signed in the new year. And a lot of communications with not only our Tsilhqot'in communities, members and elders, but a lot of the local operators, First Nations across BC, across Canada, because we feel that we thank them, many, including non-First Nations, who were big support with their process and the things that they've done in meetings, lobbying, in treaties, in the BC treaty process, in courts, in direct action, being out on the land, speaking the language, doing traditional activities. That's why we won. And we need to remember, and I was just in Heiltsuk, Bella there a couple of days ago, and I witnessed the First Nations there that signed a declaration of title, taking action as a nation moving forward. So I think we've always tried to negotiate. We've sat at the tables. We've been in meetings. This court case, this title case, was not our first option. That was our last option, and we were forced to go to court. So that's sort of where we come from. Now that this decision has come down, we've been planning, we've been strategizing. We've been involved in the Union of BC Indian Chiefs, the BC Summit, Assembly of First Nations. Part of this agreement with BC is also getting Canada to the table. So this whole process, what we're looking at is twofold. One is title land. What's happening on title land? How are we going to move forward on title land? We do have license and permits that is in front of us to deal with. We have private landowners on title land. And what we want to do in transition is to work with BC so that through our involvement, we can improve, we can look at and make decisions on title land with for the local operators in our area. And that's still in front of us. There's been few agreements with BC already, and moving forward, in this agreement is we call bridging agreements, and these bridging agreements will be in place until the transition is finished. We do have a team right now from Ani, from the Tsilhqot'in National Government, and as soon as we sign a 5-year negotiation process or prior to, BC will be involved in a transition on title land with Tsilhqot'in and Ani. And what we want to do is we need to get caught up. Stellat'en has been impacted. We're looking at housing, we're looking at education, health. We have 8 different pillars that is very important in this 5-year negotiations. And being caught up is we do have a lot of Tsilhqot'in members who have degrees, who are out on the land, speaking the language, doing traditional activities, who are, some of them who are struggling. We do have alcohol, drugs, and that are people that are caught in that gangs. And what we want to do in this whole process is to get caught up so that by the time we move forward in our title land, we're looking at outside title land, we're looking at the whole Tsilhqot'in territory with the other 5 Tsilhqot'in communities where they have want to be able to be involved in decision making, want to be able to get revenues from the Tsilhqot'in territory. So we do know that some agreements will be quick, some will take longer, but our goal is that we need to show with BC and Canada that title land is very important. It's a benefit. At the end of the day, the local operators in our area, the non-First Nations, have a better experience in title land than at the time was called Crown land. So that's our goal, and that's a sort of a quick update. So advice, if there's any, to First Nations is to continue working together, to move forward, to put a plan in place coming from your elders, from your members, from your youth. In our negotiations at each of the communities, we'll be having elders, youth, and members involved, giving directions to the chiefs on how we move forward, having experts to help us get information so that end of the day, this agreement is going to be for our future generations, and that our involvement is going to improve the Tsilhqot'in area, improve BC, improve Canada. And meeting with many First Nations across this country and learning from them, because there are agreements, there are process, there are governance in First Nations that are leading edge, and that we don't want to reinvent the wheel. We want to learn from that, tweak it, and improve it. So that's my quick update.
Thank you, Chief Roger. Great. Stay in place. I'll go ahead and close your webcam for now, and we'll bring Greg up. And two quick notes as I do that, everyone. I forgot to mention the questions pane on your the little webinar dashboard that comes up. As questions come to you, please enter them in the questions pane, and then when we get to the roundtable discussion after the presentations, we'll be able to bring you in with your question, and we look forward to it. So please take a moment as questions come to you to enter them in. And all right, Greg, I'm sending you a new webcam request, and I've opened your line. Oops.
All right. Looks like you can see me.
Yes, and hear you. Great. And let me pull up, give me just a moment to pull up those pictures that you sent. I'll go ahead and do that now.
Well, let me say thank you for inviting me, and it's an honor to follow Chief Roger. We owe Chief William and the Tsilhqot'in people a great debt of gratitude. As Jay says quite correctly, the main and most important precedent of the case is really to show that title is in fact real and that it's territorial. All of those things existed in theory before, but it's fundamentally a different world we live in today. We would not have won our case had the Tsilhqot'in not won their case. So my topic is a little bit different, and the Saik'uz and Stellat'en case is kind of the next generation. That is, if you have Aboriginal title, as so many nations do, what do the Canadian courts do to protect it? What rights do you have to go to court to protect your land from the activities of others? That in our Canadian Constitution, Section 35 is quite clear. Aboriginal rights and title are existing and protected from the actions of government. The fact that it's existing is something that in the Supreme Court of Canada in Delgamuukw, it was quite clear that title isn't created by either the Constitution or a recognition by the court. Title, it existed at the time of Europeans coming to Canada, and it's simply recognized by our legal system. So what our case deals with is English common law, causes of action called tort. To non-lawyers, there are two types of law in Canada. One is statute law, which is the laws passed by Parliament or legislatures, and the other is common law. That is a set of rules around how people act together, and including things like contract law or negligence. One of the most important pieces of law that protects land rights that we inherited from the English is are torts, common law torts, causes of action like nuisance, which protects one landowner from the activities of another. The rule says that you can do what you want on your own land, but you can't interfere with the use and occupancy of your neighbor or the use and enjoyment of your neighbor's land, and if you do so, your neighbor is entitled to an injunction to stop you. Trespass is a common law tort, which says if you come onto my land and harm it, I can seek damages from you and I can get an injunction to kick you off. Riparian rights, which is a rule that says if there are two landowners along a river, the upstream owner has the right to take water for normal use, but he can't harm the downstream owners. The downstream owner is entitled to the same amount of water, undiminished in quality and quantity. Another tort is Rylands and Fletcher, which says if you keep dangerous material on your land and it escapes, you're liable for all the damage. Something like a Mount Polly situation. So our case concerned the Alcan project, which was built in the 50s. There's a picture in front of you of a Saik'uz area along the Nechako River. That project was arguably the most environmentally harmful project in the history of the province. It dammed up the Nechako River, a major river, created a huge reservoir of water, and then diverted all of the water down through the mountains through a tunnel into the Pacific Ocean. That's a picture of the dam, which basically dammed up the river completely. Took all of the water out of the Nechako Canyon. Even today, 80% of up to 80% of the water is diverted from the normal flow and never ever enters the Nechako. They're not just holding up the water, they're basically stealing it. They took a whole river and were given it by the government of the day. Now, the Saik'uz and Stellat'en are downstream owners who've relied on this river and its fishery for their whole of their existence. This is not primarily a question of title, it's primarily a question of use and occupation of the land. But, and they have been to court on a number of occasions trying to do something about this project. But what they did in 2011 was to file a court case based on English law, common law tort of nuisance and riparian rights, saying we have Aboriginal title, we have a right to the land along the river, and that gives us rights to the river, and we have a right to the fishery, all of which have been harmed or stolen from us by the activities of Alcan, and relying on the law of Aboriginal title and the law of common law. That intersection is not well defined in Canadian law because the Tsilhqot'in case was the first to actually prove title. Now, Alcan successfully defended that at the trial level, at least in Supreme Court, by arguing a number of really fundamentally offensive things. One is that Aboriginal title is not like other land rights, and so all that English common law and the role of the courts in protecting one landowner from another simply doesn't apply. You're stuck with the law of consultation and accommodation and nothing else. The second thing they argued is that Aboriginal title really doesn't give you a right to go to court to sue individual or private parties until you've actually done what the Tsilhqot'in have done. You've got to have gone through a very lengthy court case, proven your Aboriginal title against the Crown, and obtained a declaration of title, and then, and only then, you might have some sort of right to be protected from the activities of private industry that interfere with your land. And they argued that, in fact, there was no right to sue private parties at all. You had to sue the Crown, and they succeeded at the trial level. The BC Court of Appeal decision, which occurred last year, came after the Tsilhqot'in case. So the Court of Appeal was very aware that title, at least in some parts of British Columbia, does exist and is real, and relying on the Supreme Court of Canada's judgment in Tsilhqot'in, they were able to say Aboriginal title is an interest in land. It does create the benefits. It is different from common law fee simple. In fact, it's stronger because it's constitutionally protected, but it can give rise to all of the common law remedies that of the type that English law protects. So in other words, the courts of Canada will be available to protect common law. The court said it is clear that Aboriginal rights and title exist prior to declaration or recognition. All that a court declaration or Crown acceptance does is to identify the exact nature and the extent of the title or other rights. In other words, all of the First Nations in BC who have not yet gone to court to obtain a declaration of title, but do have Aboriginal title, have as much right to have their land protected by a Canadian court as anyone else. It's a constitutionally protected right. The Court of Appeal also held that Aboriginal title is a beneficial interest in land that gives the First Nation the right to possess it, and that although it's not the same as ownership in fee simple, it gives rise potentially to an action in private nuisance, it gives rise to an action in public nuisance, and that the Aboriginal right of fisheries gives right to an action or can give rise to a title or to a claim in riparian rights. And so the net effect is that the matter can proceed. In terms of Alcan's argument that you that you had to prove these rights first before you had a claim against a private party, the court was very clear. As any other litigant, they should be permitted to prove the action against another party that the rights that are required to prove in order to succeed in the claim against the other party. Aboriginal people are part of Canada's community, and they should not be treated disadvantageously in comparison to any other litigant asserting claims for nuisance and breach of riparian rights. That case was appealed by Alcan to the Supreme Court of Canada, and a week ago, or 2 weeks ago now, the court denied their application for leave, along with a Quebec case brought by the Innu involving another division of Rio Tinto in Quebec that was very, very similar. So the law of Canada, at least in British Columbia and Quebec, is now that these kinds of actions are available. And the real implication of that is for industrial users who harm Crown land that may have Aboriginal title associated with it, or may even just simply give rise to a lawful right of use and occupation by First Nations. And just like any other landowner, the rule is you have a duty to your neighbors not to harm their rights. And the last important piece of the Saik'uz and Stellat'en case is that the court ruled that a provincial permit may not be a defense to that. In other words, Alcan had argued their water license was a complete defense and it didn't matter, but of course the provincial government has no right to take away Aboriginal rights and title, and so the court has left open the concept that those permits cannot defend against the rights of First Nations to bring actions in nuisance. So this is early days yet. We still have to go to a trial and prove the nuisance, but as you can see in the pictures, that's not going to be difficult to do. And so the net effect is that there's a brand new tool in the toolbox for First Nations, along with the duty of consultation and accommodation, along with the right to bring title claims. There's also the right to bring common law claims for protection of land. Thanks.
Great, Greg. Let me pull up too, just to help support what you were saying. I haven't shown, I think, the picture here.
Here's a before and after picture of the river before. Have you got the one next? And after. That's upstream of the dam, but that gives you a sense of the kind of magnitude of damage that was occurred. Much of that land was Tsilhqot'in land and was simply flooded.
Great. I'm just going to show that one more time. So that's before the damming and then after. Okay. Great, Greg, thank you very much. I'm going to have you, I'm going to close your webcam for now, and I'll have you sit tight, and we will bring up Jess. Great, Jess, I see you've got your microphone live, and I'm going to bring up your, oops, I'm going to bring up your picture. Hang on one moment. Let me get my ducks in a row here. There we go. There we go. Okay. And great. So I just wanted to show the picture a little bit while you're speaking, and then I'll try to bring up some of the other pictures as you refer to them. And yeah, thank you very much. And if you, can you hear me okay?
Yes, I can. Can you hear me?
Okay, great. Yes, yes, we can hear you. Thank you.
Great. So good morning, everybody. I'm come from the Heiltsuk Nation on BC's Central Coast, and I'm speaking to you today from the heart of our unceded homelands in our community of Bella Bella. So as Anne mentioned in her generous introduction at the beginning of the webinar, I serve my community as an elected tribal councillor and as the chairperson of our lands portfolio. However, I also do nonprofit work and grassroots community organizing to support the vision of a nation that is really firmly rooted in cultural identity and a sense of connection to our territorial lands and waters. Before I begin, I would really like to take this opportunity to thank Chief Roger once again as a representative of our Heiltsuk tribal government for coming to Bella Bella to stand with our people earlier this week when we launched our own title and rights strategy. I think it's really important to note that, you know, we're standing together and supporting one another, and that this is a really amazing way to move forward as First Nations people, and that when we do things like that, it really flies in the face of this idea that the government always tries to sell, that there's so much infighting amongst First Nations that we'll never get anything done. That's simply not true. To launch into my own stories, to begin with, I'd really like to share that organizing in the Heiltsuk community, we always try to root our work in three really foundational ideas, and I suspect they're pretty common across other nations as well. First, it's really important for us to remember that it's not enough to just say that we're sovereign. It's important for us to act like it too. Second, we recognize that it's really hard when you're asking people to be angry all the time, and so when we can, we try to reframe our stance in terms of what we're standing for instead of what we're fighting against. And third, we try to always go forward with many hands but one heart. Collaboration is really key in our work because we know that we're stronger together. So those organizing principles really carry us through any issue that manifests in our territorial lands and waters, and I would like to speak a little bit about two of those issues today and how they played out in our community. So the first issue I'd like to talk about is a regional campaign to end trophy hunting for bears. This issue long predates my time in politics, but it's an issue that's been really close to my heart since I took on the political role that I have today. It's simply not consistent with our tribal laws and customs to kill animals for sport, and the Heiltsuk, along with our neighboring communities, have argued that the only hunting that's acceptable to us is hunting for food and ceremony. So to shoot a bear and just take its head and paws and leave its body to rot where it fell is not acceptable to us. Now, in spite of our vocal opposition and in spite of us asserting a ban under tribal law, the provincial government continues to allow trophy hunting on our unceded homelands, and they do so on this basis. They state that as First Nations, we have no authority to end the trophy hunt. They state that the trophy hunt is supported by the best available science. They state that the trophy hunt is a strong economic driver for the province, and they state that trophy hunting is part of BC's identity. I think when we launched our campaign, Christy Clark's message was that British Columbia had a long, proud tradition of trophy hunting, and that meant more than our First Nations tradition of not killing for sport. So, realizing that we wanted to make significant change on this issue, our nations decided to strategize together. We spent a year pulling together what we felt was a really comprehensive campaign that we eventually named Bears Forever, and we started with the goal of dismantling the province's talking points one by one. So on the province's assertion that trophy hunting is based on the best available science, our rebuttal was pretty clear. 4 of our Central Coast nations are doing really sophisticated scientific research on bears. They are publishing peer-reviewed papers in reputable journals and partnering with the world's foremost wildlife biologists. So if the province is not using our science, and they're not, then they're not using the best available science. On the province's assertion that trophy hunting drives BC's economy, we invited Stanford University to do an independent analysis that compared the revenue generated by trophy hunting in the Great Bear Rainforest to the revenue generated by sustainable industries like ecotourism. You can read that full report online, but as you might expect, ecotourism generates about 15 times the revenue that trophy hunting does in our region. So much for the province's economic argument. On the province's assertion that trophy hunting is part of BC's culture, we thought it was time to ask BC. So we financed an independent polling company to ask British Columbians what they thought about the issue. Now, not only did 9 in 10 British Columbians agree with us that the trophy hunt in the Great Bear Rainforest should end, but they had some really strong opinions on other points too. 84% of people that we polled said that the province should work with First Nations to jointly manage hunting activities on First Nations territories. 87% said that First Nations in BC should have the right to prohibit trophy hunting on First Nations territory. And 92% of people surveyed said that hunters should respect First Nations laws and customs when on First Nations territory. So remember when I told you that the province claimed that we had no authority to ban the hunt? It sounded to me, when we read the poll results, like British Columbians disagreed pretty strongly with their elected government on that point and strongly supported First Nations taking leadership on this issue. So we launched our campaign with the release of our poll data, the economic analysis, and some amazing science papers. We launched with a short film called Bear Witness that showed our nations on the ground living with bears as part of our cultural learning and scientific research. And we took our campaign on the road to build some amazing public momentum. We were asking people to stand up for bears rather than oppose the hunt, and I really think that that positive framing helped us to build an amazing constituency around this issue. Our campaign had a pretty sensational start, and we were able to build a huge wall of public support for our work that's sustained over the last 2 years since we first launched. And we haven't had a fast win, but being strategic and being collaborative and framing this issue in a positive way really mounted the public pressure we needed to start a credible conversation with the province. It really helped us to get through the door and get to that table. And after 2 years of back and forth and negotiations and mobilizing that network of campaign supporters when we needed a little extra push, I can confidently say that we are on the cusp of negotiating some very significant protection for bears in our territories. And we got there by being strategic, by being patient, and by thinking 10 steps ahead. We got there by using all of the information and tools at our disposal to make a public case for what we wanted to do. We got there by grounding ourselves in laws and customs as old as our world. But not all fights are that slow to unfold. I know that the information about this webinar said I'd be talking about Enbridge Northern Gateway in addition to trophy hunting, but I bet that you all know that story really well, and so with apologies to Anne for the last minute switch, I want to actually talk to you a little bit about herring instead, because I think that might be a little more new and novel for you. So as you may have heard, this past spring, Heiltsuk Nation had quite the standoff with the Department of Fisheries and Oceans over the commercial herring fishery. We didn't get a lot of mainstream press, but that didn't stop us, I think, from making pretty significant change. So for context, there are 2 ways to harvest herring roe. The Heiltsuk do it by stringing kelp and hemlock in the water where we expect to spawn, and then pulling out our lines when the eggs have been laid really thick. Herring spawn multiple times in their lifetime, and so our method allows them to live to spawn another day. The commercial fishery, in contrast, is a kill fishery, and they harvest roe by scooping up herring balls in seine nets and cutting the eggs out of the females. Now, I know which way I think is more sustainable, and DFO's mismanagement of the herring stocks has enabled the commercial kill fishery to catalyze 2 stock collapses just in recent memory. In addition, as you may know, Heiltsuk have a commercial Aboriginal right to harvest roe by our traditional method and to trade and sell it, which is a right that was affirmed in the Supreme Court through the Gladstone decision. We have a really strong and committed interest in sustaining the herring stocks, and that's really, I think, the background to everything that unfolded this past spring. So with this context in mind, I think you can probably see where trouble is brewing. Now in 2014, we put DFO on notice that we wouldn't stand for the commercial herring opening that they'd proposed. And when we threatened marine blockades to protect key spawning grounds, we found ourselves greeted by a whole battalion of extra RCMP who were sent up to police our movements. And in the end, we were unfortunately unsuccessful in stopping the fishery that year. Now this year in 2015, we made the same position clear. No unsustainable kill fishery would happen in our waters. Again, we were greeted by an influx of RCMP to keep an eye on us. And we repeatedly made offers to DFO to sit down and talk about our concerns, as we had been doing for months, and those offers were ignored. So when DFO called a sneaky seine opening at dusk one night with the commercial fleet not in port but somehow already conveniently near the spawning grounds, it really lit a fire under our community. And I think what happened next was pretty magical. We simply had enough. So we went across the water and took over the local DFO office. We pitched tents in the yard and sent our leadership in to occupy the building. And for nearly a week, we had whole families, at times up to 100 people, living on the lawn at DFO. Our hereditary and elected leaders never left the office. We cut down the Canadian flag and raised the Heiltsuk Nation's flag while our children played in the grass and our women cooked feasts for the camp. And at the same time that we were doing that, our off-reserve members in urban areas across the province mobilized protests in cities across BC. We had Heiltsuk members blockading the Vancouver DFO office, taking over major intersections with their drum circles, creating picket lines outside the company headquarters of Jimmy Pattison, who owns most of the commercial herring fleet. And after days of this major spectacle, DFO finally sent a lone brave woman into the fray, and to her credit, she stayed in that occupied building with her leadership until they negotiated a mutually agreeable outcome. In the midst of all that, when word came from Ottawa that they wanted us to call off our protests before they would even talk to us about what we wanted, we responded that actually they needed to talk about giving us what we wanted before we'd call off our protests. As simple as that. It was really a trial by fire, and the immense public pressure worked in this case. We emerged from the DFO office to see the commercial gillnet fleet leaving our waters without their quota. We left with commitments from DFO to strike a joint management committee, and time will tell in a few short months whether DFO's kept a good heart on their agreements with us, because it won't be long before the 2016 herring season's upon us, but we've been working really hard to ensure a better outcome next spring than we've had for the last 2 years. So in the case of herring, we made change not by strategy and not through long games, but simply by rising up. So the stories I've shared represent two really different approaches to making change. I shared them because I want to make the point that our power as First Nations people is not in the specific tools and methods we choose, but it's in the truth of our really unshakable belief that this is our land and these are our waters, and no one has ever taken away our right to steward them. We've been doing it since time before memory, and our children will carry on doing it long, long after we're gone. I really believe that all you can do is create an opportunity for people to stand up and stand together. And when you do that, it's really incredible the change that can come. So, the way I see it, there's no one way of winning our fights. There's no one space in which we're powerful. But I've never been more certain of anything than the belief that we're most successful when we fight together, when we go into it with a good heart, and when we take the time to celebrate our successes and inspire one another like we're doing here today on this webinar. So thank you for listening to my stories, and I look forward to the discussion.
Great. Thank you, Jess. All right, everybody hang on for just a moment, and I'm going to try to bring up the webcams for the speakers that have those. And so give me just a moment to do that and bring up everybody's voice too. And we'll see how we do. So we've got Greg back, Jay back, Chief Roger back. Great. And Jess, you can still hear us?
Yep.
Great. I'm going to just try to bring up your picture here if I can. Just one moment to kind of get the size right here. Okay, great. Okay, whoops. Too many buttons. Somehow I lost my photo of you. I don't know how I did that. Okay, well, I'll just pull that down for a second. Okay, and I'll try to bring that back in a moment. Oh, right. So I want to encourage people on the line again to go ahead and submit your questions so I can bring them in. I'll start our panelists off with a couple of questions, but we really hope that we'll be able to bring you in, and we've got a half an hour for Q&A, which is great, and we'd really like to make that a group discussion. And if you submit a question, I will try to open your line and then let you ask the question yourself, but if we can't hear you for some reason, I'll ask it on your behalf. And so I want to pick up where Jess left off and ask everybody to speak to this a little bit, this point about the cultural activities or traditional activities of First Nations themselves are critical not only in campaigns that don't involve legal strategy, but Chief William brought up how important they are even when you are pursuing a legal strategy. And I know that that Chief William has talked about before the importance of being able to demonstrate the history of cultural activities in the area that was being looked at in the case. So I just wanted to ask each of the speakers to talk about the importance of the cultural activities themselves in these different ways of fighting fights, whether it's a campaign outside of the courtroom or in the courtroom, and if it's inside the courtroom, the importance of documenting those traditional activities as part of a case. And maybe Chief Roger, can I have you speak to that a little bit first, and then we'll have other speakers jump in.
Well, first, I would like to say that I think working together, always keeping the doors open as a community, first as a family, as a community, as a nation, and with your local non-First Nations, and everything that you do, for me is we always sat down and either through meetings or it could be negotiations, but I think it's trying to get a relationship going, and that's the first and foremost. And I think doing this in what I always think of as Stellat'en, in a respectful, honorable, but very strong stand. And I think you can do these things in a good way, in a positive way. So when we do that, that door being always open gives an opportunity for, it could be an individual, it could be a company or government, to see if there's room to work together. And I think if we can do that, I think there's a lot of things that can move forward. In doing that, you always have to, we always say, leave a good paper trail. We always work with our legal team, getting advice from our legal team, and that's very important. Creating a paper trail in a respectful, honorable way, trying to sit down and meet or negotiate, but you have your goals. You're coming from your elders, from your people, from your youth, and those goals is what you're trying to get to. And if the process is not working and you're not able to get there, you have a paper trail. Governments, companies, they make, there's decisions made and activities that they do, which in some cases are totally against what you'd like to happen. And that's what we call a legal paper trail, to make sure that, and the media is very important. People in general, even today I talk to I was in Tsilhqot'in title land. This guy was on a motorbike. He had a good, he was gonna camp out in title land and up Stellat'en through the back way. But he didn't know about title land. Maybe he might be not telling all the truth, but you know, we always, through the media, we want to let people know that this is who we are. This is what we want. There's no secrecy. This is open. And I think steps, very important, taking steps. What is the plan? What can we use in these steps? And using media in these steps is very important. So that way, not only the company and the government or the proponent or the individual, but the general public knows these steps and they see it and they see a progression. This is not like a shock that this is all of a sudden. People get angry because something comes up and they don't know. Sometimes doing this, it helps things go more smoothly. But situations, we all know that sometimes those steps you have to take a big leap to take action. And I think you need to be open for that, but you always have to have a foundation to come from. So I think in short, there's so many ideas and thoughts that I've heard, not only from my elders, from my youth, from our lawyers, from our tribal council, but other First Nations around this country, non-First Nations. I sat down and listened and talked to them, and I think you know, if we were to look at a scale, I think anywhere between 80 to 90% we're going to agree. We're going to work together. It's the 20 to 10% that we don't agree, and that seems to be the end of the world for a lot of people. But I think keeping that in perspective, I think it's something that we could, you know, we'll all learn that.
Great. Would anyone else like to speak to the question about cultural activities in campaigns, legal or otherwise, and documenting them?
If I could jump in.
Sorry, Jess, go right ahead.
Sorry, if I could jump in, I would just say really quickly that, you know, it's important to remember that the reason why we're fighting is so that we continue to be the Indigenous people we are and live the way we do and always have on the landscape. And so continuing to carry out our cultural practices and remain grounded in our cultural teachings when we're in the midst of campaigns and legal challenges, I think that's of really critical importance. You know, we're doing what we do because we are who we are, and that's really tied to our cultural identity.
Excellent. And Jay?
I think, I mean, I don't obviously have much to add to what's been said, except to say that, you know, even in a court case, it's more than about winning particular points of law or black letter law. The case really, in some ways, is about, or a campaign outside of a court case. From my observation, there's a huge educational component to it for the public and for government officials. There's a lot of misconceptions about First Nations. There's a lot of misunderstanding, and from exposure, the more people understand the values and understand a bit more that connection and the importance of an area, why it's so important to people, and they experience that. I think we see people coming around, and the poll that Jess is talking about is one example, and heard similar polls about Enbridge. There's a real growing, shifting recognition across BC. There's a lot of work to be done, but that the values that First Nations people hold, like Chief Roger says, they're not that far off, and it may be a lot closer to the general public's their vision for how the land should be managed than the government or a particular company at any time. So that outreach, or that component of exposing the rest of the world to that really special connection and quality and value system that First Nations have is more powerful than any precedent or particular case or anything like that. So I would say it is the paramount important factor.
Great. Greg, did you want to add anything on that point?
Well, let me just say this, in terms of the common law approach, the tort of nuisance is defined as an interference with the use and enjoyment of land. If you're not practicing your cultural practices on a particular piece of land, then it's not necessarily protected.
Great. There are we're getting some questions in from the questions pane, so thank you folks for sending those in. And I want to ask two fairly general questions. I see that some of the questions being submitted are really specific, which is great. Let me ask two general questions first, and then I'm going to go to the questions. And they're a little bit open-ended. We may not know all the answers to this yet, but I wanted to invite everyone to comment on this idea of the precedents from both of the Tsilhqot'in and the Saik'uz and Stellat'en case applying outside of BC. I think that's going to be of interest to a lot of people. And then the other question is this question which Jay talked about a bit, the idea that after the Tsilhqot'in Nation decision, that if title is declared after a contract is signed, then there may be the need to revisit it. And I'm wondering, revisit the contract, and I'm wondering if we are seeing any examples of that happening yet, or if just with the timing, there hasn't been enough time for that yet. And yeah, I welcome comments from any of you on that.
Let me deal with the precedent question. Obviously, the Tsilhqot'in decision applies across Canada. It's a decision of the Supreme Court of Canada, and it's basically binding on every other court of appeal. The Saik'uz case, because it's a decision of the BC Court of Appeal, is technically only binding in British Columbia, but it's considered to be persuasive in other provinces. However, the fact that there's a similar Quebec case, so we have two provincial courts of appeal having come to the same conclusion, and that the Supreme Court of Canada has denied leave, suggests to me at least that this is a precedent that will be followed by trial courts right across the country.
Great. Anyone else want to comment on that? Okay.
I might just speak to the second, I guess the second part, the question of whether this idea that even where title isn't proven, that the government and the company with the project proceed at their peril if they haven't dealt with that unresolved issue of Aboriginal title. And what the Supreme Court of Canada said, as I mentioned, was if you do proceed in that fashion without having fully addressed Aboriginal title, and the First Nation subsequently goes to court and proves title, that there's an obligation of the government at that point to revisit any approval that's given for a project or any kind of development or activity, and in light of this new reality of proven Aboriginal title, potentially cancel that approval. So that does create a fairly significant level of risk moving forward in areas where there are strong Aboriginal title claims. And as I mentioned, I think we are starting to see First Nations advancing that element of the decision in claims like the Aboriginal title claim brought by Lac Kw'alaams to Lilu Island, which would be the terminal for an LNG facility, or another Aboriginal title case recently brought in respect of the Ajax mine property by Shuswap bands as well, so Skeetchesen and Kamloops Indian bands. So I think that is that part of the decision. It is early days, but First Nations are picking up on that element of the decision and pushing forward with title claims if they don't see their title being respected or recognized in the process for approving these major projects with big impacts.
Great. And
yes,
yes.
For me, my thought is that internationally in this country, we can say that there's an Aboriginal group which won 100% rights, almost 50% title, and I think you know what's happening in the Tsilhqot'in negotiations process, learning from each other, supporting what we're doing in a 5-year negotiations process will be a very big and important step, because what comes out of that could be a very strong template. Just thinking now that the federal elections out of the way, with the new Liberal Prime Minister, I think there's an opportunity there. But coming from the tidal wind, that's huge. It's never happened anywhere in this province, country, or internationally. And we're being watched by many Aboriginal people and many governments, countries, what's going on here. And I think using that and sticking together, I feel that is very important.
Great. And Jess, do you want to come in?
Yeah, I think I would just say that I think the legal and political aspect of, the precedent that this has set has been covered really well. And in a social and cultural context, I think the important thing is just the good heart this has brought to everybody who's watching these successes happen, and the inspiration that's really rising up in other communities, seeing what these folks have accomplished and hoping we can replicate it.
Great. Great. Okay, I'm going to go to the questions that we've got. And Susan, you've got the first one. Give me a moment. I'm going to try to unmute your line for you. Okay. Susan, can you hear us?
Yep, I can hear you.
We can hear you. Great.
Hi, everybody. It's Sue Smitten with Raven. I sent my question in, and I'm just wondering, with cases like Site C and other things like that, how this new legal world might affect these judgments. And I'm coming from the place of seeing that West Moberly and Prophet River lost sort of procedurally, because BC's position was that their argument of unjustified infringement doesn't belong in a JR and isn't for federal court, it should be in BCSC. And so, I'm thinking, well, what if some of the nations on the Enbridge case are told the same thing, that they have to go to BCSC? And Jay knows I'm not a lawyer, but I'm just wondering, is this some sort of legal loophole that's going to make it hard to get a win on title and rights? That's my question.
You can see the lawyers jumping up to answer this question. It's very complex, and I'm going to keep my answer short because I'm more interested in what Greg has to say on this topic. Because I haven't been involved directly in those legal engagements, and my sense watching from the outside is like yours, that the courts are throwing up some sometimes inconsistent hurdles, procedural hurdles, into how you get these issues in front of the court and decided properly. And the two different procedures you're talking about are a judicial review, which is usually a very expedited, quick review of a government decision. And as a result, it's pretty streamlined and focused on what it can address. And then a full trial or action, which is much longer, takes longer, but it can be fuller in what it looks at. And there's a real reluctance of the courts so far to deal in a real way with infringement, with proving rights and title and infringement of them in that judicial review concept procedure. So where government is approving something like Site C or Enbridge, and First Nations want to get involved and have their rights recognized and taken into account in those proceedings, they're running into obstacles having the court deal with them there and being directed to other processes. And so right now it's a bit of a mess and it's a maze. It's an issue that's going to have to be worked out, but I don't know where that's going or what the answer to that is right now. It's one of the next major issues to deal with.
The lawyers for the other side get paid raise procedural objections all the time, it's one of the frustrating things about being a lawyer. Sometimes the toughest thing to do is to actually get before the court. Jay and Roger will tell you that every possible technical objection that could possibly be thrown at them was thrown at them on the way to their trial, and some of them complicated their lives, and some of them just took a lot of time. That's why these cases take 10 years. So Yes, if you go judicial review, they say it should be a trial. If you go trial, they say it should be judicial review. If you're in federal court, they say you should be in BC Supreme Court. It's incredibly frustrating, but that's the life of a lawyer, a trial lawyer, I think. You just have to be persistent, and you have to be careful in how you frame your actions. But eventually, as the Tsilhqot'in has shown, if you keep at it, you will succeed.
I think we need to know that there's already a template in in this decision. Before the decision, we had the Calder case of 1973. Then you got all these different cases, rights cases that led up to the Delgamuukw court case and Supreme Court of Canada decision. So I think, to me, each case that went to Supreme Court of Canada in terms of title got better and stronger. And I really feel like the next one behind Tsilhqot'in is going to be even better and stronger, and we're going to be all a part of that and contribute to that. So with that moving forward, I really feel that, yes, now we know the different steps. Now we know what Calder did. Now we know what Delgamuukw did. Now we know what Tsilhqot'in. We can improve and we can work and we can learn from all that. I really feel that you know, with these negotiations that were involved, that could be another template that we could use and moving forward. So I think BC and Canada are also, and they've like you said, they've tried everything, and they've had little arguments, and these arguments they use all these years. When you heard judges, 8 judges in Supreme Court of Canada in Ottawa on November 7, 2013, they were questioning the arguments that BC and Canada were putting forward, the evidence that they were putting forward. So I think I really feel that if BC is not going to be, or Canada or both are not going to negotiate in good faith, they know that in court is only going to get stronger.
Sachana, yeah, Roger, thanks.
And Jess, I know that you didn't speak about Enbridge today, but have you been having this experience with those cases in terms of the procedural issues? And
yeah, I mean, I think that it is to the advantage of everyone other than our nations to throw every procedural issue our way that you possibly can, and it's, you know, creates a lot of obstacles, but ultimately it doesn't dampen our resolve. And you know, if these obstacles mount up so much that this is no longer the right venue to pursue these issues, then there are other venues that we will explore as well. But all we can do is be persistent.
great, great. Okay, I have a few more questions, and they all look good. So we'll try to get to them. We have you. I'll tell you who's on our stack here: Eugene, and then Helen, and Sandra, and Katie. So let's try to get to these 4 if we can. And I'm going to call on Eugene first. Let me just unmute your line. Give me a moment. Hi, Eugene.
Hi, can you hear me?
Yes.
Good morning, everyone. Thank you all for your presentations. Really interesting and informative. I'm just kind of curious, generally, if you can share any thoughts on how you see the BC Treaty Commission process happening, and how that plays with the current conversations between the Tsilhqot'in national government and the province, and, you know, kind of thoughts on how, if at all, the province's kind of approach has changed since the decision. Thank you.
Well, I think for us, in Tsilhqot'in, we haven't been involved in the BC treaty process. We chose to go into the legal process, but we have many meetings and updates with the BC Summit, First Nation Summit, and you know, this negotiations that were involved in a 5-year negotiations process. when we do sign it in the new year, could be a new process and template of the next steps. I don't really know the details in the BC Treaty process, how the BC Treaty process has been going. We can all read the reports on that, but for myself to talk to another First Nations in the BC Treaty process, there's this confidentiality clause that they sign, which doesn't allow them to communicate with us on details. So those are some of the things that we have fun with in terms of trying to find out where things are at. But I believe that the treaty process can only improve, especially in lieu of this title decision. And with these negotiations that Tsilhqot'in is working on, that's another opportunity to make some stronger changes for the process.
Great. Any other notes on that? Okay, great. Thank you. I'm going to try to call on Helen. If I can see Helen on here. There we go. Oh. Helen, I'm trying to unmute you, but I seem to be having some trouble doing that. I'm going to try to ask the question briefly on your behalf, and forgive me because I'm going to condense it just a little, and I hope I do a fair job here. How can we, as the real Bear Clan families of Maxon Lake, reclaim our stolen lands of Maxon Lake and trap lines, which the present chief and council of Wet'suwet'en First Nations band amalgamated into their band in the 1960s, all done without our free, prior, and informed consents? So maybe the best way to look at this question is: are there times where there may be competing claims to traditional territories, and do our panelists sort of see that happening, and how do they advise people who feel like they may have a claim that might not get recognized even with these recent court decisions?
I think a quick way to answer that for me is that in our court case, we've as a nation moved forward in an area in the Tsilhqot'in, and in this area we didn't have any overlaps until the 2003 December 11. I guess the Delta move where Canada had put an order in Council for First Nations to file their title. What we did there, when we had some overlap with, we had the Hamatla First Nations, Comalco, and also the Esket First Nations. We sat down with them and negotiated an agreement for that particular area. So I think trying to sit down first and foremost, come to agreement of an area, and if there's any overlap or competing interest, to meet with those to those communities or nations to resolve them before you file your court case. That would be the best way to move forward.
Jess, did I hear you?
If I could just add to that a little bit. My nation has not been involved in the treaty process for a very long time, although some of our neighbors are. And it is not a quick or a sure way to build collaborations necessarily, but one of the things we've tried to do is focus on issues that are bigger than any individual claim, so things like a unified response to trophy hunting or something like Enbridge, and use those opportunities that really transcended boundaries to work together and build relationships that made it more possible to then have frank and respectful conversations about the more specific issues later on. I don't know whether that's a possibility in your area, but it's been something that I think has been beneficial here.
Great.
I should comment that you know, these, not on the specific facts there, but the need to resolve internal governance issues is fundamental. It's part of the inherent right of self-government. You have to exercise it, and you have the right to decide how you would be governed, but you don't want outsiders answering that question for you. And if there are those sorts of internal governance disputes, they will be exploited by outside companies and government to your detriment. So getting those matters right, although it's not easy, it's essential.
Great. I'm going to, Sandra and Katie, forgive me, I'm going to, your questions are similar, I think, so I'm going to combine them into one and voice it. They are both asking about how the non-Aboriginal community can support the claims of First Nations and also facilitate collaboration from outside of the Aboriginal community. And any comments on the role of social media and other media related to this are most welcome.
Maybe I'll just jump in. I think one of the more remarkable things about the Supreme Court of Canada decision in the Tsilhqot'in case, and I think maybe something similar happened in Haida as well, is that the local non-First Nations people living in what became the tidal area actually collectively intervened, applied to court and got standing and supported Heiltsuk and the Tsilhqot'in Nation at the Supreme Court of Canada, saying that they, as the people most directly affected by the decisions, the non-First Nations people most directly affected, supported finding of Aboriginal title and rights, and in their experience, recognizing rights was the only way to a positive relationship with the First Nation. And it really, I think, on some level, I can't know what's inside the minds of the judges, of course, but diffused that the fear and anxiety that gets played up in these cases around the impacts for non-First Nations people. So that maybe that's a bit of an exceptional example, but that type of relationship really does go a long way. And in the battles, the struggles that the Tsilhqot'in have had with large mining proposals in their territory, they successfully have kept out the new prosperity gold mines. There were coalitions of non-Aboriginal people who came together specifically for the purpose of communicating to government, the media, and environmental panels when they came through that you know, the Chamber of Commerce and the BC government aren't speaking uniformly for all British Columbians or even all the people in the local area, that there are people in the region who strongly support what the First Nation is trying to do, and I think that had a tremendous impact there as well. So that's just a couple examples.
Anyone else want to add to that?
If I could speak to that a little bit, I would just like to say that the allyship of non-First Nations people has been really critical in turning the tide on many of the campaigns that I've worked on, and I think that the support that exists in the wider world for what we do as First Nations is really evident. You know, we saw it in the poll results for our Bear campaign. We see it in the droves of people who are participating in campaigns like Pull Together, which is raising funds to support the First Nations who are fighting Enbridge Northern Gateway in court. We know you're there, and it's so important to us that you're there, and any way that you can find to elevate our voices and elevate what it is we're doing and make it easier for us to do what we're doing, whether that's by donating or participating in fundraisers or organizing fundraisers, showing up at court and standing outside the courthouse when we're walking through those doors, finding ways to be visible at the moments where we might be really daunted by the enormity of the tasks we're taking on. You know, all of those things are really important and they're really appreciated.
Wonderful. We have... Oh.
I was just going to say that usually First Nations, you know, advisably would always involve the local non-First Nations when we move forward. But if a non-First Nations is feeling that's not happening, I think that the best way to do it is set up a meeting with the chief and council, and from there, it's really hard to, I guess, to be able to answer this question, because I think First Nations in general, we do have a history with the local non-First Nations in our area. A lot of them is like for several generations. So, but if there is a case like this, and I'm sure there is, the non-First Nations, it's advisable just to try and connect with the leaders and with some of the staff. There are some of the communities have communications coordinators or people you can talk to try and get that relationship built.
Wonderful. We have 2 more questions, and but I'm conscious that we're already a little over time. So what I would like to do, and Lynette and David, and I think there may be one more question too that just came in. I will put those questions to our panelists via email and then post answers along with the recording of today's webinar so that we won't have to rush through them, but also we'll be able to be mindful of everybody's time. So I appreciate your patience on that. And I just want to thank Jess and Greg and Jay and Chief Roger so much for presenting today, and for everybody who joined us and to listen and learn and share and ask questions. Thank you so much. It's an honor to be with all of you today.